Hello, good morning, everyone. My name is Cynthia Williams. I'm a professor at Osgoode Hall Law School and one of the principal investigators of the Canada Climate Law Initiative with doctors Janice, Sarah, and Cara Luau at University of British Columbia. And thank you for joining us this morning. CCLI was started at Oxford University and is a collaboration between academics and practitioners to evaluate the fiduciary obligations of operating company directors and pension fund trustees in a number of Commonwealth countries. We have an engaged network of experts who are available to come and give expert presentations to companies pro bono. And we encourage you to look to our newly launched website and Knowledge Hub. Today, we are delighted to bring to you a significant new opinion by Randy Bauslaugh, counsel at McCarthy Tétrault, on pension fund trustees' fiduciary obligations. We, I think, can all agree this has been a banner week. At the beginning of last week, the International Energy Association published its roadmap to 2050. The G7 ministers of finance pledged no more financial support or government support for international coal expansion. On Friday, the White House issued an executive order about climate change risk across financial institutions, insurance, and across the entire US government. And then just before we went online here today, we understand that a Dutch court in Den Haag has ordered Shell to reduce its greenhouse gas emissions 45% by 2030. So, what do all of these developments mean for those of you who are pension fund trustees? As I said, we are delighted to have commissioned an opinion, but the opinion is, it is independent of my views or other CCLI views, an opinion by Randy Bauslaugh, and to have Catherine McCall to provide some questions for Randy. Randy is a lawyer with one of Canada's largest business law firms, McCarthy Tétrault. He is co-chair of McCarthy Tétrault's National Pensions Benefit and Executive Compensation Practice and its 45-lawyer National Pension Funds Group. He provides legal advice to plan sponsors, to administrators, service providers, and governments on a wide range of pension and benefits issues, and has been involved in many of the leading cases in Canada over the last 35 years. He also provides advice to a number of different international organizations and associations of actuaries, foreign governments, the United Nations, UNEP-FI, and the Principles of Responsible Investment. He's to be questioned by experienced interlocutor Catherine McCall, who is the executive director of the Canadian Coalition for Good Governance. The coalition is comprised of representatives of Canada's leading pension funds and asset managers, in collectively managing assets close to $5 trillion. Its mandate is to improve the corporate governance of investee companies, and that is Canadian public companies, including board oversight of environmental and social issues. As executive director of CCGG, Catherine develops CCGG's agenda and strategy and its policy initiatives. She is a lawyer by training and is a member of the Ontario Securities Commission's Continuous Disclosure Advisory Committee. the global network of investor associations and is designated as the Canadian country correspondent for the International Corporate Governance Network. So please join me in welcoming Randy Bauslaugh and Catherine McCall.
Thanks very much, Cynthia. And I'd really like to thank the Canada Climate Law Initiative for reaching out to ask me to do this. It was a privilege to be able to do it. And so thanks to you and Janice Sarah at the UBC Law School. I also just briefly want to thank the C.D. Howe Institute. Alex Laurent, the Director of Research, looked at a very early version of the paper and gave me some comments. And you'll find in the paper that I had access to research that the C.D. Howe Institute had done last summer relating to the climate change management practices of 40 of Canada's largest pension funds. I also want to briefly thank the partners of my firm for their comments on this paper. I did want it run by them before disclosing it, and that was really helpful. And I feel absolutely thrilled to be being interviewed by Catherine McCall. So thanks for all of that. And also thanks to the CPBI, the Canadian Pension Benefits Institute, for supporting this initiative amongst their members. So I thought I just, I understand everybody has received a copy of the paper. If you don't read the footnotes, it probably takes you about 15 or 20 minutes to read the whole thing. But I just wanted to comment a little bit on my approach to writing it. It really isn't written for other lawyers or academics. I mean, there's enough in it for lawyers and academics, but it's written to be readable to anyone basically in the pensions industry. For most of my career, I have not dealt directly with lawyers within clients, which is kind of odd for a large, lawyer at a large business law firm. Most of the people that I deal with on pension and pension issues tend to be HR and finance people or the general managers of large plans. And so the approach I took is how I would write an opinion for them, something that can be read and understood, not only by lawyers and academics, but even a more casual reader. The opinion is a little bit longer than I wanted, but part of the problem is, as Cynthia alluded to in her introduction, was it's like there's this daily barrage of more information about the economic and financial consequences of climate change, not to mention social, cultural, and other things that are happening as a result of climate change. So it was every day I was just sort of adding a little bit more to it. At some point I just had to say, stop, let's get on with getting this out. Now I just want to turn to the paper itself. The other thing I don't do is I don't write suspenseful opinions. I don't let clients don't have to read the whole opinion to get the answers. I once had a client who said, can you just highlight the sentence I need to read? And I said, well, you really need to read all of it because you've got to comment on the context. But at the same time, I try to put the conclusions up front. So all of the basic answers to the questions I was asked to take a look at are all summarized in the introduction. And so basically what I had concluded, and I guess this is the heart and soul of it, is this is an unqualified opinion that those responsible for managing investments or selecting investment options for investment in defined contribution plans must take climate-related financial risks and opportunities into account or face potentially personal liability. The paper explains a little bit why the liability may be personal. It also explains why in a fiduciary context, there may be more remedies available than in a contractual context. But I think the paper is pretty clear. The failure of plan administrators and their investment agents and advisors to take climate change financial risks and opportunities into account is a breach of fiduciary duty, and it threatens the ability of their plan to deliver on what are tax Act says must be their primary purpose, namely to deliver lifetime retirement income. And I was trying to be extremely clear with that, and I hope that comes through in the paper. The second thing that I wanted to deal with was, and it comes out of having read the McVeigh case, which is described in the paper. It's a case out of Australia where someone was trying to get access to information about whether his pension plans managers were taking climate change into account and how they were managing the risks and opportunities presented by climate change. So the second thing that I hope people get out of this paper is, it's a more qualified opinion on disclosure obligations. The paper concludes that there might be an ongoing common law or civil law obligation to disclose whether climate change financial risks and opportunities are being taken into account, and how they're being managed. I mean, based on the opinion I just articulated, I think it would be very foolish for any fiduciary to ever say they don't take climate change into account. But whether I think there's some doubt about whether they have an ongoing disclosure requirement. I think there's less doubt that if a pension plan participant were to complain to a pension standards regulator about wanting access to what's being done in connection with climate change, the pension standards regulator may be inclined to say, yeah, let's pursue that as a request. So anyway, the point is the paper provides a more qualified opinion on the disclosure obligations, and certainly on any ongoing disclosure obligation. So that brings me to a third point that the paper makes, and that is I think it's a pretty strong recommendation that policymakers address any doubt about ongoing disclosure of the management of climate-related financial risks and opportunities by passing legislation that would make disclosures mandatory. And what I was and what I've set out in the paper is that disclosure rule ought to be along the lines of what the province of Ontario did in connection with ESG factor disclosures, but to the extent to which, so basically identifying in a statement of investment policies and procedures and in annual statements or other periodic communications with plan members, just whether they're taking ESG factors into account, and if so, how. And I would suggest that Ontario rule is a good starting point with an added specification to specifically or explicitly address what they're doing about climate change. Then lastly, the opinions I write for clients, I try to provide some practical advice. And so the paper does provide some practical pointers or tips or practical advice in relation to the management of climate-related financial considerations. By looking at what the 40 largest Canadian pension plans are doing, and also just based on my almost, I guess, about 38 years of experience advising fiduciaries of a broad range of pension plans that range from the very, very small to the very, very large, and all sorts of design types ranging from traditional defined benefit to defined contribution to hybrid target benefit, defined ambition plans, etc. I think these practical suggestions should apply to all sorts of plans. So, I mean, that's basically the territory that the paper covers. There's a couple of other things that are in the paper that I just wanted to mention. I know I did insert a paragraph to make it absolutely perfectly clear that the analysis here is coming from a perspective of value, not values. This is not any perspective that advocates for changing the planet or taking a moral or an ethical or a social or cultural view of this. It's just purely, what is fiduciary duty? And as people will know, I've written about before, including last year, there's an article which I can't remember the exact title that I wrote, but it was something along the lines of a mantra, an ESG mantra for pension fiduciaries. And basically just repeat to yourself, it's about value, not values. And so the point I wanted to make is in the paper is that this is really coming from that perspective, which I think is very consistent with the legal analysis. And then the other point in that I wanted to just, maybe we can come back to greenwashing and impact investing, but I do have a concern about impact investing from both a common law and then more specifically from a Canadian perspective. Impact investing is having a focus on making some sort of a change alongside a financial return. And that is going, in my mind as a fiduciary, if I'm looking at a manager who says they are an impact investor or they do impact investing, and this is going to, be consistent with their fiduciary duties, I would say, there's something, an alarm that ought to go off where you need to dig into it a bit more deeply, because I think impact investing it's a sort of from a pension plan fiduciary perspective, it's kind of a schizophrenic kind of view. The primary purpose of the plan, and certainly I think from a common law perspective, and most definitely from a Canadian perspective, and I'll explain why in a moment, it's a financial purpose. So that financial purpose needs to be primary, and so it's not just alongside. It's not trying to make a change alongside of an investment return. It's trying to preserve your investment, reduce your investment risk, mitigate your investment risk, and make sure that you've got, in your scoping out investment opportunities. And if that happens to have an impact on the environment or something else, well, that's good. Or you might use that consideration as a tiebreaker or something, but the primary fundamental purpose needs to be financial. And just briefly, why I keep saying, I think from a common law perspective, the County Scargill case, I find it hard to swallow some of the criticisms it received based on its particular fact pattern. I mean, you've got a board of trustees composed of union and management trustees, and the leader of the union, who is one of the trustees, is saying, we are not going to invest in products that compete with coal, and we're not going to invest outside of the country in coal because we want to preserve union jobs. Excuse me, that is not the purpose of the pension plan. The purpose is to deliver retirement income. That's what they need to focus on. That's why the decision was correct. That's what it did. And it doesn't in any way, shape, or form preclude other considerations, in my view. And it is possibly one of the best statements I think that's out there in terms of what the law actually is in this area. So anyway, I just wanted to make the one point. The paper is really about focusing on value, not values. In terms of the law, coming back into the law, I've done governance training with clients or in other settings, and governance training for fiduciaries. And I always start with the Keach and Sanford case from 1726. And I know some of you may be saying, why do you start way back in 1726? And I just think it's a good story. It's a good story to tell clients based on the facts to point out how closely fiduciary duty comes to being a moral or ethical obligation. And it's one of those few areas of the law where, you've heard this expression, it may not be legal, or it may be legal, but it's not right. And more often than not, when in fiduciary law, if it's not right, it probably isn't legal. But I think, the more important points is that unlike contract law, there are more remedies available. There's more of a moral impetus to do the right thing, which involves also being loyal to the purpose of the plan, amongst other things. And so you'll find that analysis in the paper, but it all bleeds out of Keach and Sanford. And I just find the facts tell a good story. And I'm not going to go through the facts, but it's basically, well, maybe I will. This guy Keach was a child, and this fellow Sanford was appointed as his trustee until he became an adult. The child had inherited a lease, and when the lease came up for renewal, the evidence was that Mr. Sanford used his best efforts to get it renewed, but the landlord just said, I'm not going to renew it for a child. So Sanford renewed it for himself, and then when Keach became an adult, he sued Sanford to obtain an accounting and reimbursement of all the profits he had made. And the judge in that case, acknowledged this might be a harsh result, but fiduciary duty meant that Mr. Sanford was probably the only person in the whole world. I forget what the words he used. It might have been something like, meant Sanford may have been the only person of all mankind who might not have the lease because of the conflict of interest that was perceived to exist, even if he had taken all these efforts to try and get it moved over. So, and I think it just points out the nature of fiduciary duty. The paper goes through, our Supreme Court of Canada recent decisions relating to fiduciary relationships. It goes on about the nature of fiduciary duty in a corporate context, where it's the purpose there is for the benefit of the corporation. And I think there's an analogy to the best interests of the plan itself. I do go through Count and Scargill. I do point out that the two fundamental fiduciary duties that are at play here are the duty of loyalty and the duty of prudence, and I try to explain what it is. I've seen mushy legal commentary around ESG and climate change issues relating to where they bring the duty of loyalty in as some sort of a duty to adhere to the social, cultural, or moral inclinations of the plan beneficiaries. And I just want to say it has nothing to do with that. The duty of loyalty has to do with managing conflicts and being loyal to the purpose. And where that purpose is financial, that's what is going to direct you, or being loyal to the terms of the plan. Now, in Canada, I keep mentioning this, and I want to make sure I make the point. For a tax qualified plan in Canada to maintain its tax qualified status, the primary purpose of the plan must be to provide lifetime retirement income. Clearly a financial purpose, and it must be the primary purpose, not a secondary purpose, not an alongside purpose, but the primary purpose. So that may distinguish the Canadian scene a little bit from other jurisdictions, and I know that there are people from other jurisdictions plugged into this today. So I just wanted to point that out, that we have an income tax directive that to maintain the tax qualified status of a workplace pension plan, the primary purpose has to be provide those that lifetime retirement income. And then, of course, the other case, which it's sprinkled throughout the opinion, is the recent Supreme Court of Canada decision in the Greenhouse Gas Pollution Pricing Act. Now, this is a constitutional reference case, which means the federal government had enacted legislation to tax or set prices on greenhouse gas emissions in order to meet its Paris Accord obligations, amongst other things. And when it did that, not all of the provinces got upset. They felt that all or part of what the federal government was doing was stepping on their powers to tax or regulate emissions in their own provinces. So it became this constitutional reference. And so what has this got to do with pensions? Well, as part of the case, all of the parties, so all of the provinces and the federal government, all agree to some basic facts. And those basic facts are climate change is real. It's caused by greenhouse gas emissions. Those emissions result from human activities. And those emissions pose a grave threat to humanity's future. Now, the decision also references sort of an economic impact, and it does say at one point, it is, in quotes, well established that climate change is causing significant environmental, economic, and human harm nationally and internationally. So in the end, the law gets upheld in part because it's clearly a matter of national concern, I think, driven by those facts. So I don't think it's appropriate for pension plan fiduciaries in Canada who are regulated by provincial, mostly provincial governments, but also in some instances where the plan covers people in a federal sphere, by the federal government, to ignore climate change as part of their fiduciary obligation. It's real, it has an economic effect, and presumably, since every government agreed that those were the facts, if your, pension standards legislation is provincial and federal, so if someone raises a complaint that maybe their plan administrator isn't taking this into account, I think they need to be aware of the fact that the government who's responsible for that regulatory agency feels it is a relevant factor, just simply because it has an economic effect. And that economic effect in the Greenhouse Gas Pollution Pricing Act case, it seems to indicate that it's a response to systemic economic risk across all sectors, all parts of the economy at all times. So I think you, again, yeah, you may ignore it, but if someone complains to a regulator, I think they may end up taking up the cause. So I just want to make that point. I don't think that point is, I mean, there's a reference to that in the paper, but not as forceful as that. The last thing I want to talk about just briefly before I turn it over to Catherine to interrogate me, or interview me rather, is the intersection of finance and science. I wrote a first draft of this paper that started with the science, mostly because I'm used to presenting evidence. You present the evidence you have, or the facts as you know them, and then you discuss the law, and then you apply the law to the facts. And I thought starting with the science was the place to start, but I quickly learned that starting with the science ignites debate, because a lot of the science relates to projections mostly about how bad it's going to get, or how bad it could get, and sort of when that might happen. And it's all about projections, and there's debate about that, and that just increases the level of political debate about the reality of climate change, et cetera, et cetera, et cetera. So what the paper does is it focuses more on the observable facts that the climate is changing. We can measure that, and we've measured it for decades now. The temperatures are increasing. That's observable fact, measured since the 1970s. The increased temperature, the science says that should result in increased precipitation. And guess what? The measurable fact is it has resulted in increased precipitation, more flooding, more extreme weather events, and measurable increases in sea levels, et cetera. These are all observable facts relating to physical changes. And we also have observable and measured financial consequences arising from those physical facts. So there is a factual basis for saying, I, as the investor of assets, or responsible for the investment of assets, need to take that into account. But having said that, like, you can rely totally on the financial consequences and the financial facts. But having said that, I still don't think that fiduciaries can entirely ignore the science, because there is this integration and intersection of the two. And let me just give you an example. So the science that's subject to debate indicates that the so-called committed effect of carbon now in the air. Committed effect means if we just shut the taps off now, got to zero emissions today, there's still carbon in the air, and the effect of that we are committed to in the future is a continuing rise in temperature and a continuing rise in sea levels. Now, there's doubt about how much temperature rise or how much sea level, about how bad it gets and when, but if the science estimates that a minimum sea level rise of 1 meter or 1.3 meters, I think is what the minimum is based on the committed effect today, and a maximum of several meters. And the science is a bit fuzzy about whether we hit those, that minimum or even the peaks in 3 decades or 7 decades. Doesn't matter. The fact is the best predictive information and insight we have is we're going to have a 1.3 meter rise in sea levels, and we're going to have more temperature increase. So if I'm a fiduciary and I'm contemplating investment in a long-term commercial or residential development in Lower Manhattan, I think that provides me a little bit of insight. And one of the things that's necessary for fiduciary investment is a bit of confidence in the investment you're about to make. And I think that shakes up your confidence a little bit in whether that really is a good long-term bet. On the other hand, if I've been presented with an investment maybe in an infrastructure project in Lower Manhattan to build, strengthen, or maintain dikes or other barriers, I think it helps to inform me about that investment in terms of, well, maybe that's not a bad bet. So there is going to be this continual, I think, intersection, even though the legal premises that I've spoken about doesn't proceed from the science, it proceeds from the measurable, observed effects of climate change and the measurable, observed financial consequences that we've experienced thus far. So why don't I just stop it there and then turn this over to Catherine.
Thank you, Randy, for that excellent and succinct overview of your opinion. And there's a lot of material in there, and I have a lot of questions, but I wanted to start first with one that came from the audience, just to clear things up. Could you explain what an unqualified opinion is?
Well, I once had a client that said, geez, I just want a one-handed lawyer. I don't want a lawyer who's giving me an opinion. It says on the one hand, on the other hand, on the third hand, the fourth hand. I just want a one-handed lawyer that just tells me what the answer is. And frequently lawyers are, we don't know exactly what the final opinion has been. So we don't give unqualified opinions. We give opinions that are qualified. Well, it's based on this particular fact or this particular circumstance, or if this happens or that happens, and if this happens, it could go this way, and if that happens, it could go the other way. This one, the evidence is so clear, and the law is so well established that I don't have any qualifications about saying, if you are a fiduciary and you are responsible for investment management of pension funds, you are at risk of being in violation of your fiduciary duty if you fail to take climate change into account. No qualifications, no ifs, ands, or buts.
Okay, and we'll circle back around to disclosure and your views on that later, which is more qualified of a view. So I want to start off by asking you, why is this opinion significant and why now? Why is the timing significant?
A couple of reasons. First, I think just to clarify the law a little bit, I don't think there's real clear statements, especially on the pension side, that we've seen out there. And I think I think this opinion is significant because of the unqualified nature of my conclusion about what your fiduciary duty is in the context of climate change. I also think that in the pension industry, we're a little bit behind the 8 ball here. Securities regulators have identified climate change as an important factor. They've issued guidance back in 2019. The bankers have gone there. Their financial institutions or financial service entities within our economy in Canada have already acknowledged climate change as something that needs to be addressed, and the pension space just hasn't. So when Janice and Cynthia reached out for me to do this, I thought, yeah, let me do it. Let me really dig into this, and because I think we can add some clarity and maybe a little bit of catch up here.
And the time is definitely now, if not before.
Yeah.
So if we're not late, one of the arguments that you hear often with respect to climate change is that it's a political issue and that trustees should be staying away from politics. So how would you respond to that argument?
Well, you know what? It is a political issue. Like, there are people who are climate change skeptics. It's as odd as that sounds to many of us who can see the observable consequences of climate change. So there's going to be debate. As I said earlier, I think the science itself opens up that debate. So I would never talk to a climate skeptic by starting with the science, because they'll just dispute it and turn it into a political issue. It is a political issue, but trustees can't avoid it because it's also a financial issue. And I mean, I think, so I think it's not something that trustees can ignore. They need to pick it up because it is because of the financial implications. What they don't want to do is get sucked into a debate about the science, because I think that's where the politics starts surfacing. There's another aspect of this too, and that is that employees and other stakeholders of pension plans have political interests, or politically motivated interests in some cases, in this issue of climate change. Pension funds are big asset owners that can assert influence on the climate change agenda. So pension plan beneficiaries, employers participating in the pension plan, but mostly I think plan participants, they may be coming at this issue from a social, cultural, moral, or purely environmental perspective, where they want change on this, and it's political. And they want their plan administrator to pay attention to them. And I think that's another thing that plan administrators can't ignore, because there's reputational risks and there's a confidence risk, if I can put it that way, about how participants feel about their plans. So they need to respond. And I've actually just a week or so ago was asked to review an investment policy relating to climate change for a public institution, and they wanted it to deal with their pension funds as well as other funds. And I think the way that you can best deal with it is you can't ignore their concern. You acknowledge their concern, but you do it without committing to prioritize the values part of the equation I was talking about before. Over, you're not going to commit to prioritize their values over the value considerations you need to take into account as a fiduciary. At the same time, you can acknowledge their concern. You can acknowledge the information that they've brought to you about the importance of climate change. And I'm not talking about just trying to, brush them off with some platitudes, because sometimes they bring information that's really, really key. So you acknowledge that, but you don't commit to prioritize that over the value consideration. So in this whole piece, communications is critical. I think, you do the polite thing, you thank them for their input, and then you try to, I think what the best approach is to be as transparent as you can. You try to communicate the pathways to the change they want that could result from your investment approach and your engagement with managers and with investing entities. It's, I just don't think you can avoid that politics. And then the other thing I probably should reference as well is because a year or two ago, one of my clients was going to conduct a poll or a vote of plan members on what they ought to do. And there was a strong desire amongst a certain population within the plan that the plan should be divesting itself of any fossil fuel companies at all. And and the client, I think, was prepared to actually do this as a poll and then try to go in that direction. And I reminded them that as a fiduciary,
Mhm.
you can't just delegate your fiduciary responsibility to a poll. Like, you can take the poll and you can take it into account, but ultimately that decision about whether this is a good fiduciary decision to do what you're about to do, it's on you.
Mhm.
Poll is just one of the factors you took into account. At the end of the day, you got to keep your eye on that finance ball and prioritize value over values.
Yeah, and as you said, the fiduciary duty is not to the plan beneficiaries, it's to the plan itself and the pensions that have to be there for future generations and
Yeah, and
a
there's
long time.
just an interesting story. I was on the board of directors for the Canadian Cancer Society for 6 years. I was the chair of the HR committee. I went to my second meeting. This is back in the 90s, and we were going through our statement of investment policies and procedures for the plan, and I saw that there was a prohibition on investing in tobacco products, and I came to me and said, so can somebody explain to me under what authority can we have a prohibition on tobacco products investment in the pension plan? And people around the table looked at me like I was from the moon and said, Randy, we're the Canadian Cancer Society. And I said, well, it's one thing for you to say that, and with respect to our endowment funds, the purpose is to reduce the incidence of cancer, to help with the healthcare response to cancer, et cetera, et cetera. So since tobacco is an agent that we believe causes cancer, I can see where you would eliminate that or put a barrier up to investing in tobacco in that context. But the purpose of our pension plan is to provide lifetime retirement income. It has nothing to do with cancer whatsoever. So we have to find another reason for us to be able to keep tobacco, off our list of investments. And we were able to do that by going back in and writing a trust agreement and amending the trust agreement to say, our primary purpose is to provide lifetime retirement income, but we will also endeavor to avoid investment in things that are known to contribute to cancer, blah, 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 blah. And that, the problem solved. But I think it's you can't just say because we're all working in the same industry and working towards eradicating cancer. We can say in our pension plan, all of these workers, we should put at risk or introduce, a barrier to investing in a particular thing because we think that was what our members might want us to do.
Yeah. You've said in your, before that, I think in your opinion as well, that climate change is more urgent than COVID. Like, how can that be?
I think there are two aspects to the answer to this. One is if you just take a look at the damage, the property damage that gets caused by climate change, and you can just take, for example, even insurance claims relating to property damage that results from flooding, because we know two things as a fact: climate change causes the temperature to go up. When the temperature goes up, we get more rain, and observable fact is we've had more precipitation. In every decade, we get more and more and more. And if you just go look at the property damage claims from that increase in precipitation, I can't put my fingers on the numbers for Canada. I just went over the one for China from the 90s. It's $11 billion in claims, property damage claims from flooding. The next decade, the average annual damages are something like 34 billion. So it jumps from 11 to 34 billion. And the expectation is for the next decade, it was going to go up again, but even more than it had jumped from the 90s. So that's a big number. And then if you're not, and that number doesn't take into account flooding could damage a water sewage treatment plant that then contaminates local drinking water. So there's costs to repair that. There could be, there's remedial costs associated with that. There could be population dislocations. There could be damage that requires a movement of a business from one place to another. None of those extra costs are factored into this stuff. And you can find this data online. So the actual physical amount of damage that is going to be done by climate change in this year is probably not far off what what we expect the economic damage to be from COVID.
Mhm.
And then the other thing is coming back to that committed effective climate change. We know that as we keep adding carbon, it keeps cascading in terms of extreme weather events, in terms of hurricanes, cyclones, wildfires, all that sort of stuff. That, like with COVID, we've had this period of, a year and a half or so, and then it's going to be over, and we're going to start to repair the economic damage that was done. With climate change, we're not. Like, it's going to continue to get worse, and all we can do is try to address it with adaptive technologies that will put a finger in the dike here and a finger in the dike there until we get more of those adaptive technologies and it starts to change the whole thing around. So so even though COVID feels more urgent because we see it and we see the impact right today, with climate change, we have this aspect where we've got it now, and unless we address it now, it's just going to get worse in the future.
The Cynthia was mentioning earlier about the International Energy Association's roadmap to net zero energy by 2050. And part of that roadmap states that there should be no exploration for oil and gas, no new exploration for oil and gas, no new coal mines or expansion of existing coal mines. So how does that report influence your views on pension funds, trustees, fiduciary duties? And I also mentioned what Cynthia mentioned as well, that Biden just released the executive order that references pensions and lifetime savings. So could you comment on that as well with respect to fiduciary duties?
Sure. Well, I mean, when you get things that are coming out of well-established institutions like the IEA, like, I don't think as a fiduciary you can kind of ignore that information. If you already hold fossil fuel companies, you might expect something even, something's going to happen there. If you know that the IEA is recommending this is the International Energy Association, so it's the industry itself saying no new developments here. So if you were looking at a new development, maybe that comes off your list of things to look at. I'm not sure it reinforces any of the legal conclusion that's in the paper. It's just one of those, when I was talking about how science intersects with your fiduciary duty, I think, this is just more information that you can put together to determine whether you're taking on more risk by either continuing with fossil fuel developments or going into one, or maybe you should be moving away from that yourself so you're not at risk and starting to look at adaptive technologies or something else.
You state in your opinion that the service providers to plan administrators also have a fiduciary obligation to take a look consideration of climate change under common law, civil law, pension law. Could you elaborate on who within the chain of intermediaries and the are subject to these fiduciary obligations? Are the asset managers? Are the accountants? Are the actuaries?
Yeah. I think it's kind of all of the above, depending, again, this is one of those qualified responses. It depends on what you're retaining them to do. If I'm retaining most small funds, and most of the funds in Canada, as I said, are, I think over half of the pension, the workplace pension plans that we have in Canada have fewer than 10 members. So this isn't something that's within the knowledge of the person who's ultimately responsible for running the plan or the board of the company that's decided to put it in place. It sits on the side of somebody's desk along with a lot of other things that they're focused on, like HR issues or finance issues. And so they rely on these other managers. And if I'm relying on that other manager, I have a right to expect them to, I'm retaining them, and my contract with them ought to reference this, that I have got reps and warranties and indemnities, that they are experts and they have special expertise. And increasingly, I'm suggesting clients put in specific reps and warranties or acknowledgements relating to their ability to take into account climate change. So from a common law perspective, they know I'm relying on them. There's a relationship there, And so I think that engages, common law fiduciary duties and civil law fiduciary duties. But most of the pension standards legislation in Canada also says explicitly that the agents of the plan administrator, which is our term for the fiduciary, because the administrator can take in one of a number of, it could be a trustee, it could be just an insurance company, or it could be the employer itself. But the experts, the agents they hire to do stuff for them, are going to be the same standard as the trustees themselves. And if they have special knowledge and expertise, they're going to be held to that higher prudential standard of that special knowledge and expertise. So actuaries, they will try to, say that they're independent and there's not that reliance there, but I don't know, I wouldn't want to be in a courtroom arguing that that my client isn't relying on me for this expertise if I was an actuary, because nobody understands. I think actuarial, I think, is actually a separate language, and accountants maybe, like they're just trying to set, maybe they're not in the same league as the accounts. Investment managers, for sure, rely on them for the particular mandate that they have. Lawyers, well, sometimes we can dissociate from being their agents. We're not their agents, we're their professional advisors, and they're not necessarily relying on us to help them make decisions about what investments to make. They're relying on opinion to say they could be on the hook if they're not taking into account the right sort of thing. So there's a whole, range of advisors and experts in the issue as whether they're really acting as some kind of agent for decision making.
Now, you were talking about the number of small pension plans in Canada and how very many there are. And I wanted you to talk a little bit about what pension plans can do, what procedures they can adopt and follow to meet these fiduciary obligations, but also because smaller plans are obviously not going to have the resources, how can they adapt? What can they do to adapt those best practices?
Yeah, sure. Well, small funds, they're probably not going to have, as you suggest, the sophistication to be able to devise an investment, like an in-depth kind of investment policy around this issue that is going to be any more sophisticated than that it will be taken into account in the selection and evaluation of investment managers. That's probably all they can say. And then when they make the decision, they will minute their decision, and they may say, this manager, we're not sure that they're really strong on the climate change part of it, but there's other benefits to getting them based on their performance or their expertise in some other areas. So it's okay for us to then hire them, but we've at least thought about it. That's all we can do as a small, fund. In many respects, I really like the approach taken by the UK. Earlier this year, they've got draft legislation that's out there expected to come into effect in the fall, with very specific rules for pension fiduciaries, including best effort requirements to set climate change goals, climate change metrics and reporting. But it's only the large funds that are going to have to comply by next year. And then I think by 2024, 2025, there's some sort of what I call medium-sized funds, with the possibility of excluding smaller funds. But they're going to expect those smaller funds are going to upgrade their knowledge skills so they can at least understand what they're being told by their agents and others. I just don't think Canada can go that far. By the way, the UK approach picks up most of the recommendations, or it seems to be picking up most of the recommendations, I think, that were proposed by the Task Force on Climate Change Disclosures. And that is obviously, I think that's the gold standard, or maybe whatever higher than the gold standard that ought to be followed. But realistically and politically in Canada, I'm more concerned that our regulators at least put this on the radar screen, because otherwise we're jeopardizing the ability of our whole tax deferred pension system to deliver retirement savings that are going to be adequate enough to help people maintain their standard of living throughout their retirement. So I think it's from a policy perspective, it's not just alerting these people to the fact they may have fiduciary responsibility. It's helping the whole system deliver on what the system is set up to deliver.
We're running out of time, so I wonder if there's one last question I could ask you to answer quickly, if it's possible. You hear a lot about the argument about divesting or engagement with companies. Should pension funds sell their fossil fuel interests, or like, is that obligatory to divest of these high carbon investments?
Well, the short answer is it kind of depends, but there's a published debate between me and another lawyer on this issue that they took the position that divesting is not the right strategy. It's taking a look at what you own and what kind of influence can you have on either the investment manager or the investee entity itself, because I do have, if I have a big position, I can pick up the CEO of that company and talk to them about, what are you doing in terms of transitioning to something better? Because we're not happy with the way things are going now. Or I can exercise my proxy voting rights, or I can do a bunch of other things before I get to the point where I can even sue, as I'm an owner, and I can sue. If
you lose all the ability to do all of that effective action if you've sold. That's all off the table.
If I sell, I'm sitting on the sidelines with my fingers crossed, hoping to do the right thing. Yeah.
Interesting. Well, we have run out of time, so thank you so much, Randy, and I'm going to turn it over to Cynthia for the concluding remarks. Thank you.
Well, thank you very much, Catherine, and thank you, Randy. Thank you, Randy, in particular, for the clarity and also the sound legal foundation for your opinion. We very much appreciate it. The opinion is going to be sent out to everyone who's registered for this webinar, along with a recording. And I also just want to emphasize that CCLI has 70 experts who, legal experts, who are very happy to speak with boards, speak with pension fund trustees, share our expertise, and it's all done on a pro bono and entirely confidential basis. But thank you very much. And let's see what tomorrow brings, given how fast things are changing.
Thank you, Cynthia.
Yeah, take care. And thank you to our audience for a stream of excellent questions. We did our best to incorporate as many as possible. And we do appreciate your interest.
Thank you.
So, goodbye.